Hello and welcome back to the one-day moot workshop organized to introduce you to the various facets of mooting. Up until now, we have been looking at the procedural and theoretical aspects of mooting. However, now we will be focusing on much more practical case, and that is exactly the point of the prology of moot. The prology of moot is going to be a simulation of what actually happens during the oral rounds with the assistance of the procedures which have been explained to all of you during the previous sessions. It will be easy for you to follow through. However, if there's any other questions, you can still ask. I would be explaining the detailed rules regarding the prologio shortly, but before that, I would request our principal, Dr. Pratima Prabhakar, to officially flag off the first event by the Moot Court Society 2020-21.
Thank you, Diksha. Good afternoon, everybody present here. Respected Reverend Father Praveen Rudheraj, dear Professor Pauline Priya, the Vice Principal SJCL, faculty coordinators of SJCL Moot Court Society, esteemed faculty members, dear students, SJCL Moot Court Society, and all our students. A warm welcome to you all for the afternoon session of the workshop. Well, mooting can be best described as an activity which gets a person closest to being a lawyer while still in law school. Participation in moots will be the passport to enter into the bright future in litigation, and tomorrow belongs to the students who are willing to work hard and prepare well today. The students are required to have sufficient experience of moot court environment before they actually enter into courtroom after graduating. The experience of moot courts equips the students with the analytical, argumentative, observational, drafting, advocacy, research, communication skills, time management, dealing with deadlines, and more than anything, it teaches you on how to do a teamwork efficiently and effectively. It gives wide exposure to the field of litigation, and it is, of course, incredibly challenging both mentally and physically. I understand that mooting can seem daunting at first, but once you understand the basics and have jumped the hurdle of trying it for the first time yourself, trust me, then it becomes a great fun. Mooting is one of the best things you can do to get a sense of what it's like to be a legal advocate, giving you the opportunity to get on your feet and argue your case in front of someone who knows the law inside out. It is also an impressive addition to any CV. We had an informative session in the morning by Mr. Vikyant Oberoi, shared his experiences in mooting in a very understandable manner, and our very own students brought out beautifully the various facets of mooting. One of our goals is to train the mooters well, especially the first years and second year students, and to arrange for interactive sessions with experienced mooters and to organize extensive workshops and demonstration to enable them to learn the process of mooting from the very basics to the most intricate details. The present session is in furtherance of our goal. Mooting is happening everywhere, and it is also happening place near to you. There are mooting competition at almost every level, from institutional to international. SJCL will be conducting a national level moot court competition in the following semester. SJCL encourages, supports, and trains the students to participate in such competitions. The institution has a robust screening, and we would be shortly conducting internal screening rounds and finally select students to represent the college in the respective moot court competitions. This is a wonderful opportunity for me to place it on record that our faculty members have not left any stone unturned in training the students, and our senior students have done extremely well in various moot court competitions and made us very proud by bringing laurels to the institutions in a very short span of 3 years. And we are immensely happy by the fact that our students are always willing to help and assist the junior students in all curricular and co-curricular activities without any limitations and hesitations. Thank you so much, dear students, for making the SJCL a better place to be around. Finally, a piece of advice for all the future advocates and aspiring mooters is to cultivate the habit of reading extensively. A lawyer without reading books would be like a workman without tools. Well, if you're already an avid reader, my hearty congratulations to you. Also, my hearty congratulations to all those students who decided to participate in moots, since you have already half won. Because deciding and committing yourself for moots is the biggest challenge. As rightly said by Abraham Lincoln that if you are resolutely determined to make a lawyer of yourself, the thing is more than half done already. Wish you all the very best in your pursuit to become an excellent mooter and researcher. I now declare all mooting activities for the year 2020 and 21 in our college open. Thank you so much.
Thank you, ma'am, for your kind words. Now we will be beginning with the first official event of the Moot Court Society. If you would have noticed, we have circulated the proposition for the Prolesio Moot via the CR group yesterday, and you were advised to go through it during the course of the lunch hour as well. The Prolesio Moot will be judged by our faculty coordinators, Professor Sudeep Sudhakaran and Professor Sangeeta Thomas. So during the course of the Prolesio Moot, I would request all the participants to maintain their audios on mute. If you choose to switch on your videos to observe the proceedings, that's completely on you, but please ensure your audio is on mute. We would not be entertaining the questions during the course of the moot court session. Once the session is over, we will let you know that you can ask the questions. The mooters for the present Prolesio moot are Rishika M from the fourth year BLLB. She has participated in various moot court competitions and was also and had also received the highest speaker scores for the intra moot rounds last year. We also have with us Anita Verghese from fourth year BLLB, who has won the best researcher award at the moot court competitions, and she has participated in various moot court competitions. The Prolesio will be a simulation of the oral round, guys. So kindly pay attention to the mannerisms and as well as the presentation of the arguments. Now I would like to formally initiate the Prolesio moot and invite Professor Sudeep and Professor Sangeeta Thomas to begin the proceedings.
Councils, you have 10 minutes each to present your side. Calling the council number 1. And your time starts now.
Am I visible and audible? Can I just get a confirmation?
Yes.
All right. The counsel for the petitioners requests permission to speak.
Permission granted.
Permission granted.
The council requests permission to address your lordship and your ladyship as your lordships.
Granted.
The council requests permission to proceed to the matter at hand.
Yes.
May it please your lordships and your ladyship to note that the petitioner has approached this court under Article 32 of the Constitution of Indica, which guarantees the petitioner the right to move the Supreme Court for the enforcement of the rights guaranteed to them under Part 3 of the Constitution of Indica. In light of the same, this court is well within its jurisdiction to hear the present matter and to issue any order, writ, or direction that it may deem appropriate or necessary for the enforcement of the rights of the petitioners guaranteed under Part 3. Now, to briefly state the facts of the present matter, in order to tackle the issue of illegal immigrants in the state of Indica, the government of Indica introduced the Citizenship Amendment Bill of 2019, the provisions of which are considered to be in gross violation of the principles of secularism and are considered discriminatory against the Islamic community. In response to the same, the enactment there were several sit-in protests conducted, organized against the enactment by the Shia, and this was also visits at the protest sites and through their statements. Now, the ruling government party, has spread widespread discouragement against these protests by citing public inconvenience as the reason and affixing their stand that they would not roll back the enactment. The protests soon turned violent and resulted in bloodshed between the Sindhus and the Islamic community. This incident mainly involved students and members of certain political groups. The incident resulted in various state governments taking cognizance of the situation and asking the protesters to halt their actions. But continual denial by the protesters and an explicit incident where a call was made through the loudspeaker of a mosque calling for the Islamic community to continue their fight for justice resulted in the state governments taking action and ordering internet bans in various cities. The petitioners have hence moved this court for the enforcement of the rights guaranteed to them under Part 3 of the Constitution. Now, the issue at hand is clear, Your Lordships. The petitioners contend that the internet ban is violative of the fundamental rights guaranteed to them under the Part 3 of the Constitution of Indica by virtue of three rationales. First, the right to access the internet is a constitutionally protected right under Article 19, Clause 1A, Subclause G of the Constitution of Indica. Second, the ban does not satisfy the principles of reasonable restriction that have been provided under Article 19, Clause 2 and Clause 6, respectively. The ban also violates the right to life and personal liberty guaranteed to the petitioners under Article 21 of the Constitution of Indica. In light of this, yes, my lordship.
What's the ground of saying right to internet is a protected right under Article 19?
Thank you for the question, Your Lordship. Your Lordships, in the case of Anuradha Basan versus the Union of India, the Honorable Court, observing that the prevalence and the extent of the internet proliferation in the in the lives of one cannot be undermined, has held that the right to access the internet and the right to express yourself through the medium of the internet and to carry on trade and occupation through the medium of the internet is a right protected constitutionally under Article 19 under Article 19 Clause 1 Subclause A and Article 19 Clause 1 Subclause G of the Constitution of Indica. Now, of course, the petitioners understand that these rights are subject to reasonable restrictions under Article 19 Clause 2 and Clause 6. However, these restrictions need to satisfy the threefold test laid down by this Honorable Court, which is the test of necessity, of reasonableness, and proportionality. Now, the restrictions also can only be imposed on the petitioners if the danger caused or the danger apprehended has been caused by the actions of the petitioners, which is not the present case. In the present case, the government has itself created a situation of law or public disorder, wherein it is members of certain political outfits and the police have taken violent action against the protesters who are merely exercising their rights at the protest sites. In light of that, the government is merely using this as an excuse to restrict the rights of the petitioners. Now, the government is clearly trying to further its agenda and imposing these restrictions. But the Council would like to point out that the restriction can only be imposed when there is a direct nexus between the use of the internet and the violence caused at the protest site. In light of that, the government is now mere messaging through the medium of the internet or carrying on daily essential activities or even e-commerce or even accessing information by medium of the internet has not caused the danger or the violence that is apprehended at the protest sites. Just because it is convenient for the government to shut down the protesters, it cannot impose such a harsh and unnecessary measure on the rights of the petitioners.
Counsel?
Yes, my lordship.
You had cited Anuradha Basan as an authority saying internet is an
fundamental right, or the access to internet is a fundamental right. Counsel, are you aware of the facts and the judgment of the case?
Yes, Your Lordship, I am aware of the fact. So, to briefly state, this matter was taken up before the court in context of the internet bans imposed in the state of Jammu and Kashmir. In this matter, the court held that the government could not impose a restriction on the access of internet of the citizens of Jammu and Kashmir merely because of the danger apprehended due to terrorist activities being carried out in the state. The court also issued a direction on the state government to take measures.
More to proceed.
Thank you. The court also issued a direction stating that the government should take measures to lift the internet ban. Now, in light of that, I would also like to bring forward the case of S. Rangarajan and P. Jagjeevan and others, where the court held that the restriction must be justified on the anvil of necessity and not on the quickstand of convenience or expediency. Rights cannot be suppressed on account of a threat of demonstration or processions of violence, processions or threats of violence, because this would tantamount to a negation of the rule of law and surrender to blackmail and intimidation. It was also held in this case that the anticipated danger should not be remote, conjectural, or far-fetched. It should have a proximate and direct nexus with the expression, and it should be inseparably locked with the action contemplated, like the equivalent of a spark in a powder keg, which is not the present case. Mere access to internet services such as e-commerce, educational sites, artistic content, even medical facilities cannot be said to cause the danger apprehended under Article 19, Clause 2. Also, a restriction for a restriction to be reasonable and proportionate, there should not be a less restrictive alternative available, which is not the present case. Hypothetically speaking, if the government could somehow prove a direct nexus between the use of internet and the danger contemplated, then it would still choose to partially restrict the access to internet services by, say, blocking social media accounts of the person spreading hateful messages, or blocking access to sites promoting such content, or even by way of preventing access to social media as such. But it has not done that. It has prevented access to ordinary activities too, such as e-commerce, education, artistic content, as I have previously stated. So, since there's clearly a possible alternative, which is less restrictive, that is available in the present case.
You have the last 1 minute to present.
Yes, of course. Thank you. So, the partial regulation is the possible alternative that the government should have taken, and since they have failed to do so, this cannot be considered proportional or reasonable. Also, the internet is also an enabler of multitude of other rights, including the right to life and liberty guaranteed under Article 21 of the Constitution of India. Now, the United Nations has also declared this to be access to internet to be a human right. In this context, some of the rights violated by that are incidental to right to life that are violated by this internet ban are right to communicate and express oneself, the right to sustain oneself economically, the right to education, the right to choose, the right to medical aid, the right to carry on everyday essential activities, the right to feel the protection of the expansive connectivity of the internet. The same was also held by the court in the case of Sabu Matthew. In this context, I would conclude by reiterating that this internet ban is clearly disproportionate, excessive, and arbitrary, and this court must hold that it is in violation of the rights of the petitioners. With this, the council requests permission to proceed to the prayer.
Yes. Right.
In light of the issues raised, arguments advanced, and authorities cited, it is prayed before this. It is prayed before this honourable court that it be pleased to quash the order of the state government banning access to the internet services, or pass any other order, direction, or relief that it may deem necessary in the interest of justice, equity, and good conscience. All of this is humbly prayed. Thanks.
Thank you, Council number 1. Council number 2. You have 10 minutes to present your side, and your time starts now.
Am I audible?
You are.
Yes. The counsel for the respondent seeks permission to approach the court.
Yes, granted.
Much obliged. The counsel for the respondent seeks permission to address the court collectively as your lordships.
Yes.
Much obliged. If your lordships are familiar with the facts of the case, the counsel seeks permission to begin with the arguments.
You can proceed to arguments.
The council hereby submits that the internet ban imposed by the central government has not violated any fundamental rights envisaged in the Indian constitution, particularly Article 19 clause 1 clause A and Article 19 clause 1 clause G. Elaborating upon Article 19(1)A, the council submits before the court three main arguments. Firstly, the right to information, freedom of press, and the freedom to participate in democratic processes can be restricted by the government in public interest. It is guaranteed under the Article 19 clause 2 as the reasonable restrictions. Counsel for the respondents would like to draw this court's attention to the situation that unfolded in light to the CAA enactment. The citizens had come to streets and had begun to express their dissent violently, with preposterous attacks on the police force as well as the peaceful civilians. It was more necessary than usual to put a ban on source that catered to misinformation. That was internet. Wrong messages about CAA were being forwarded on social media, and the internet causing a grave threat to public order and the security of the state. So this was the instant or occasion wherein the government imposed a ban on internet. The council
Counsel.
reiterates that
Counsel.
if Fellowship.
So don't you think there is a difference between reasonably restricting something and totally banning something? In this case, total ban of internet has happened. So it's not reasonably
So
restricting such comments or such posts or such social media activities that is propagating such violent activities, but total ban of the internet. So don't you think there is a difference?
Indeed. Your Lordship, I'm coming to this point at the end of the my arguments, with like contesting with the petitioner's argument. Okay, if the council seeks permission to proceed with the arguments.
Yes, proceed.
Much obliged. The council reiterates that right to information is not absolute and is restricted by reasonable restriction under 19 clause 2. Here, one more thing, it has to be the court has to look into one more thing, that the right to information is not completely banned. Internet is only one of the medium through which the right to information can be accessed. So it is not the complete restriction upon the right to information. Also, right to information does not carry an unrestricted right to gather information. A reasonable restriction is always permissible in the interest of the security of the state. Events followed by CAA demanded such restrictions, and the council submits that the said internet ban was well within the scope of reasonable restrictions and hence permissible under Article 19 clause 2.
Council.
Secondly, the council.
Yeah. So, Article 19 clause 2 allows the government to impose reasonable restrictions. But the same has to be done only through a legislative act or through the help of a legislative. There should be a parent act that allows you to do so. Which is the act, in your case, that you have imposed such a ban?
There is three things. Section 144 of CRPC imposed the government to impose a ban on the internet, and also Section 69A of IT Act. Then there is also the temporary suspension of telecom services rules 2017 that has been enacted by the government. So this under all these together, the government is empowered to impose restrictions on it. The council seeks permission to proceed with the
Proceed.
much obliged. Secondly, the second main argument is the council hereby submits that there has been no violation of freedom of press in the instant case. In the case of Amir Kasab versus State of Maharashtra, the court clearly stated that major security concerns had been posed by news channels regularly reporting about the placement of security forces, making it easier for the perpetrators to defy security. For the securities of the state, the freedom of press had been curtailed for a short while in the country. The situation preceding the internet suspension can be compared to Amir Kasab case, wherein the internet had forcibly provoked many perpetrators to inflict violence. In the instance case, the vandalism was engendering a legal provision making penal speeches or expression on the part of the individual to incite or encourage the commission of violent crimes such as murder cannot be entertained, and it will undermine the security of the state as well. So also the religious incidents were also escalating through the internet and social media, which demanded the immediate government action through reasonable restrictions. Thirdly, the Council hereby submits that a detailed case of reasonableness and proportionality is established in the current scenario. So, the said prohibition clearly abides by the doctrine of proportionality and reasonableness. One of the postulates of the reasonableness is the duration for such a restriction was imposed. All across Indica, the duration of internet ban did not exceed 48 hours. This is a de minimis time span to impose any substantial violation of the fundamental right. This again proves the government's bona fide intention in imposing such a restriction. The court has held that the doctrine of reasonableness must change with passage of time and absorb the current socio-economic values as exemplified in the telecasting case. The government's reassortment to internet ban is reasonable and was in accordance with the prevalent social circumstances, as violent information was being falsely circulated during the time. No, so this act of the government cannot be entertained as an arbitrary action. Reasonable restriction have to be determined in an objective manner, and the same was adopted by the government. Then, when it comes to the doctrine of proportionality, is also this is also maintained in the given scenario, as complete prohibition of the internet is justified in these critical circumstances, wherein both public order and the security of the state were threatened. The petitioner contend that the petitioners contend that a partial ban would suffice. However, in a number of cases, this Honorable Supreme Court has upheld the complete restriction on fundamental rights is in pursuance of public interest. So, the situation that unraveled after CAA warranted a complete ban, and the said ban did help in monitoring fake news. Thus, the restriction and the objective it sought to achieve was not too far-fetched, and thus limiting freedom of speech and expression for public interest is justified here. Hence, the Council submits that there is no violation of Article 19 clause 1 clause A in the present case. Further, elaborating upon Article 19 clause 1 clause G, the Council submits that the petitioner have drawn a bleak picture of the internet ban. This internet ban was imposed as a consequence of the alarming commotion created by the circulation of false news. As for the loss of freedom to conduct business, the government order was only anticipation of greater losses, which will not only affect the e-commerce businesses but also the businesses in physical space, as vandalism and destruction to public property was rising in this scenario. To prevent such mishap, the governmental order was absolutely crucial in this case. The Council also submits that the said ban falls within the purview of reasonable restrictions. As in the application of fundamental right to carry business, the court has permitted invoking the principle of level playing, subject however to doctrine of public interest. So it was held in the doctrine of the level playing was held in the case of Reliance Energy Limited versus Maharashtra State Road Development Corporation Limited in 2007. So it is mainly maintaining a balance between public order. Thank you. And every citizen freedom to practice trade, business, and commerce. So it is maintaining a balance between public order and the citizen's right. So the Supreme Court has held that the laws restricting such a right under Article 19 clause 1 clause G has to satisfy two distinctive tests. First being in the interest of general public, that's also established here, and second being a reasonable restriction, that's also justified here. Further, in case of Cellular Operators Association of India versus TRAI in 2016, it was held by the court that the regulation must pass the test of manifest arbitrariness and must be a result of intelligent care and deliberations. So thus the reasonable restrictions are valid in the instant scenario because it was intended to prevent vandalism through hate speeches and triggering comments. The respondent would further like to justify the complete ban in light of the petitioner's contention that a partial ban is still justifiable. But
Your time ends now.
The council seeks the permission to proceed with the arguments to wind up.
Kindly wind up within 1 minute's time.
Much obliged. So, in the case of Narendra Kumar versus Union of India, it was held that the word restriction can include prohibition in the background of circumstances, taking into account the nature of the evil that sought to be remedied. In this case, the evil was massive and was violently circulating across the internet. It would be inefficacious to monitor specific sites in order to impose partial ban in this case. So the complete ban was the best alternative and it was a necessity to stop activities inherently dangerous both locally and statewide. Thus a complete ban on the internet is constitutional. Now the council, now the council seeks to conclude all the arguments. The internet ban was not violated any of the fundamental rights guaranteed to the citizens of India, especially Article 19 plus 1 plus A and Article 19 plus 1 plus G. The said ban falls within the purview of reasonable restrictions, and as a complete ban on the internet is constitutional, the said prohibition stands justified. It is therefore the council seeks permission to submit the prayer before the court.
Yes.
It is therefore more respectfully prayed that this honourable court may please to hold and adjudge and declare that the current imposition of the government, the ban of the internet, should be held constitutional. And alternative issue a writ in the nature of mandamus or any other appropriate writ, direction or order declaring that Citizenship Amendment Act 2019 is constitutional and the current ban imposed is constitutional and should be accepted in good spirit. For such other orders as this honourable court may deem fit and proper in the interest of the justice. All of which is humbly prayed.
With this, we have come to an end with the prolosium moot. The simulation that we have just seen of the oral rounds of a moot court competition. We would now be accepting any questions or queries which might arise, and I would like to invite Himali to moderate the presentation.
Hi guys. So just to walk you through what happened in the Prolosium Moot just now. One, you could observe both the petitioner, both the counsel for the petitioner and both the counsel for the respondent address the bench. So you saw them address them as lordships collectively. You hear them seeking for permission to continue with the arguments, and so on. And that is also one of the most important rules and rubrics that have to be maintained during a moot court presentation. Then you also had the two counsels talking about the statement of jurisdiction, which means they've made it very specific that they were under Article 32 of the Constitution. Then we move on to state the statement of issue, as in what their problem is. And the counsels also, especially the counsel for the petitioner, correctly laid out the facts, and the facts which are absolutely relevant. So she went on to talk about the protests and things that were absolutely relevant to the given proposition. Then we also had certain legal principles being stated, the most relevant legal principles. For instance, they talked about freedom of speech and its expression, Article 19, which was their overarching law. And that was being dealt with by the petitioner and the respondent. The respondent was dealing with reasonable restrictions, and the petitioner was dealing with how freedom of speech and expression should not be restricted, and that in this situation it's not reasonable at all. And you also saw their lordships address and intervene, asking them a lot of questions about law, more questions of law than questions of facts, and therefore that's how a real moot court happens. And in the end, you also had a part where prayer was stated. So prayer is, I think it has been told to you in the earlier sessions, and prayer is simply what you expect as a remedy from this court, and that's how you end your moot. So this is a small walk through what just happened. Now you guys can go on with asking your questions. You can put it in the box there, in the chat box there, or you can unmute yourself. But raise your hand first and then unmute yourself.
You have muted yourself.
We can't hear you, man.
Shazia, Shazia, you're muted.
Students, there appears to be a technical glitch. Please wait while the problem is resolved.
There's a problem.
Himali, you are audible now, madam.
Yes.
Himali, yeah, you are audible now, madam. Please continue.
Yes, ma'am. I should go ahead. So the first question here is, what is reasonable restriction? It's a very legal question, and as a student, I can only tell you that under articles, so in the proposition that was given under articles 19 clause 2 and 19 clause 6, there are certain reasonable restrictions. So 19 clause 1 subclause A talks of freedom of speech and expression, and a reasonable restriction is that the state under the guise of these reasonable restrictions can curb or curtail that freedom of speech and expression, and that is given under the Constitution as under Article 19 clause 2. Similarly, Article 19 clause 1 subclause G talks about freedom of trade and commerce, and under Article 19.6 the state is allowed to curtail those freedoms, and that curtailing, the guise under which state can curtail, is called reasonable restrictions. If you want more, I could ask our judges to come in later, but not now. So, guys, just refrain from asking legal questions, more on the procedure, please. So the next question is, do the judges often allow you to extend the time the way it happened here? Usually, yes, 1 or 2 minutes, but not more than that. But it's completely at the discretion of the judge. Do the judges in the end pass their judgments? There is no elaborate judgment like that happens in a real court, but there is a feedback sort of a session that's given often by judges. And if they deny to extend the time, what is the expected response? You will have to conclude by any chance. And yes, the prayer is where you need to conclude your given. I mean, if the judges don't extend your time, there's no way you can go ahead. You just have to stop where you were, actually. Can restriction amount to prohibition? Guys, I'm very sorry. It's a legal question I cannot answer. How do judges usually judge participants on what basis? So every organization or an institution that organizes moot court lays down its own criteria. But the usual criteria is about your oral presentation, how you present yourself, your dress code, of course, and the legal language that you're trying to put forth in your arguments, and of course your moot memorials. That is also assessed. So first there's an evaluation of your memorials, your memorandum, which is your written submission. Then there's an additional evaluation of your oral rounds. Oral rounds go on in different categories, as in there's a preliminary, there's a semi-final, and then there's a quarterfinal, there's a semi-final, and there's your finals. So in each round, whatever happens, the consolidation of it is put across together. So can one of the participants, Rushika or Anita, come in and answer this one question on legality, which talks about, can restriction amount to prohibition? Any of you?
Yeah, am I audible?
Yeah.
All right, this is Rushika here. Okay, so when we talk about reasonable restrictions, so when you see Article 19, Clause 2, it provides certain grounds on which the state can impose restrictions on the right to freedom of speech and expression. So these, for example, it could be public order or security of the state or integrity of India or relationships with foreign nations. These are some of the grounds on which they can impose these restrictions. Now, it would be considered reasonable when there is a direct proportional threat, when the threat is huge, when there are certain when there is no other alternative to handle the situation, these restrictions can be imposed. So in that context, if there is a necessity to impose a complete ban also, a complete restriction or complete prohibition, even that would be considered reasonable, provided that it was necessary at the time. I hope I've answered the question. If there's anything more, you can let me know.
Yes, I will call you out if there's anything more on legality. So the next question is, but what exactly are we supposed to present? There is a lot to research and stuff. I think moot court is about research, and yes, there is a lot of research, and that's why I think in the previous sessions, my friends as well as me told you that the research, it's a commitment of about 1 or 2 months. So there's a lot of research. There is no slack on research, guys. The more research, the better your moot is. The next question is, how long does the oral round in moot court competition generally last? From the moots that I've attended, they've been 30 minutes with 15 minutes per council. So council one takes 15 minutes and the other council takes 15 minutes, and we need to reserve our own time if we want to give them rebuttals. But it depends on each competition. There are competitions that have it for 1 hour as well. That completely is at the discretion of the institution that's organizing it. The next question is the prayer statement included within the time limit? Yes, it is within the time limit, because the prayer is what tells you what you're actually seeking in that particular plea or under that written submission or your oral argument that you just made. Also, there are how many rounds in moot? I think I've catered to that question, but I will again respond. It's usually preliminary, quarter, semis, and finals, but depending on the participation, sometimes some semis and quarters are put together, and there's one preliminary, then there's the second round, a merging of both quarter and semis, and then there's a final. But usually the 4 rounds, if it's a decently known moot. When do rebuttals take place? Rebuttals usually take place after both the rounds are over. So after the petitioner has done his or her part, and petitioners have done their part, and after the respondents have done their part, there's a time allotted for rebuttal from the petitioner, then rebuttal from the respondents, as the case may be. Does the timer stop when the judge asks questions? Yes, the timer stops when the judge asks questions, but the moment you start responding to the judge, the timer starts again. The next question is restrictions on trade and commerce. Rishika or Anita, would you like to comment on that? Restrictions on trade and commerce. All right, so I think I've just been informed that we'll take DD questions later. So I'll move on to the next question, which is how many case laws do we have to present during our argument and support our point? Any number, as long as you're able to fit in within your argument. In your written submissions, I was told by my moot mentors that there should be 90 to 100 case laws in the written submissions, but you can't bring in all in your oral arguments. So whatever is the most relevant, but when you bring in case laws, remember you have to know the facts, you have to know what the judgment is, and what was even the minutest of the obiter dicta has to be known to you, which is the opinion of the judge, because once you give a case law, it's open to the judge open to their lordships to roast you in any way from any part of the judgment. So if you're bringing in case law, make sure you completely know about it. Then the next question goes, since there are 2 speakers per team, Do both speakers get chance to speak? Yes, you have to equally divide your time. There is no other way. That's the basic conduct, basic code of conduct. You have to equally divide your time. You may not have to equally divide, but you need to make sure you present your case in an equal manner so as to express your thoughts. The next question is, do we get different case in each round of the competition? No, not at all. You're dealing with the same legal issue and the same proposition. It's like it's like a holistic thing for all 4 rounds. You are doing the same thing. As mentioned in the prior session in regard to the script, is the counsel allowed to glance at the prepared script every now and then, or is the counsel required to remember the entire script and present it at so guys, you're not reading out a script, right? This is not your public speech or anything. You have to have your arguments in your fingertips, but for your case laws, you can refer to the script. So if you have case laws and facts of the case laws, you can refer to it, but please do not read. You cannot read from a script. And you won't have a script actually. Your script will be in the form of a written submission. Your petition, whatever is given, is what it is. So, yes. Is that all? Wait, just one more question, which says, so you keep the same, the judges can ask questions based on written submissions? Yes. Written submissions can completely be so the judges are given the written submission a day before, or a couple of hours before they're judging your round. So they're aware of what you've written on your written submissions, and they will completely ask you on what you're saying. Some judges kind of ignore what is written on the written submission and go on to just focus on your oral arguments, but that's a rarity. It's usually that they focus on both. So you keep making the same arguments in each round? Yes, you keep making. Depends on the side you get. Sometimes you get petitioner, and then the next round you get respondents. Obviously, you change your argument. But otherwise, yes, it remains within the same purview of arguments. Can a memorial be altered for certain mistakes that have been found in one round for the next in the event that you go forward to the next round? Yes, so that is your trick. That depends completely on your creativity. As long as you're able to hide that mistake that you've made in your oral arguments, it's completely fine. Guys, I'm just gonna clear that on this one point. I'm very sorry. You cannot make amendments to the memo that has been submitted. Okay, you can only change that in your oral arguments. Arguments in I'm not sure if I'm heard. Okay. Yes, sorry, there's a technical glitch. I'm very sorry about that. Was I heard when I said the memorial cannot be altered, but you can only, if there is any mistake that was made, you can only try to cover it up in your oral arguments. Then the next question goes, arguments and procedures, what we make will be the same in both lower courts and higher courts. There is no lower court or higher court. There's only one court that you're approaching when you're in that round. So it's just one court, whether it's the High Court or the Supreme Court, depending on how and what your proposition entails. So the judge can pick on any case mentioned in the written submission. Sadly, yes. So you would ideally have to know most cases, but of course, if you're putting 100 cases in your memorial, the judges won't be able to deal with all 100 cases. So the cases that they more prominently know. So if you have, so for instance, Maneka Gandhi in your case, of course you can know what Maneka Gandhi said. Maneka Gandhi's case said. So yes, that way you'll have to remember your case. So it's always better to remember the facts of your cases. Yes, I think with this, we end our question and answer. I will hand this over to Shazia now. Over to you, Shazia. Thank you, Himali, for answering all the questions in detail. If any more questions are there, you all can approach us, the MCS, and ask the questions. Also, meanwhile, I would like to bring this to the notice of all the participants. I hope the Prolusio and the prior sessions have encouraged you or brought in the interest to participate in moot court. So we have something very exciting coming planned for all of you. In the month of November, that is this month, we have planned two separate moot rounds. That is one for the freshers and first and second years, and the other moot will be for the third, fourth, and fifth years. Now, these rounds will determine your rankings. Do not worry. Do not worry about the performance of your moot court. Do not get intimidated by what you have seen. If you are, just that we all will also have a help desk for you, so that any query, any problem that you encounter, we will have it addressed immediately. So we encourage that you participate in the upcoming moots that we have planned for you. We will be organizing for you. Do not wait until your last year or your penultimate year. Start mooting right from your first year, because by the time you reach your second or third year, you'll realize the transition in your mooting skills. The first time obviously may not go perfect, but do not worry. That is what the MCS is for. The MCS will make sure that you get every resource that you need, you get every help that you need, and go for it, guys. Dive in, and we are always there to help you. Any query regarding how to join the how to start mooting, you can once you participate in the RK moot and the IRR, that is the internal ranking rounds. Those are the ones that are coming up. You will get to know everything about it once you participate in it. Right from your research to your oral rounds, we will help you. Do not worry. That is what we are here for. The proposition will be released shortly. You will have to start working on the proposition. The rules for both the RK moot and the IRR is different, because as one of them had asked earlier, as a first year, what is more advisable? So keeping in mind about the requirements of first years and the second years and the third and fourth, fifth years separately, we have planned, the MCS has planned things accordingly. So I encourage you, reach out to us at any point, start mooting, because this is an integral part of moot court, and every law school is known for this. Besides that, every corporate, every litigation lawyer, everyone in the legal field really looks up to this. And by the end of your fifth year or your third year for the LLB, you will realize how much it has helped you in enhancing your skills as well as your CV. Now, that is the most important aspect. So any problem, reach out to us, guys. Again and again, I've been specifying on it. I've been stressing on it. Do not get afraid, or do not feel that you cannot do. You can do. It is just a case that you have to research on and speak about. And it's really simple once you start doing it. All right. So Any questions regarding the upcoming moot, or any questions that are you have a couple of minutes for that before we end the session. Or I now invite all right, so we have the attendance form. I would like to bring that to your notice. Kindly fill the form as soon as possible before the window closes. When will be the upcoming moot? Within a week or two, we have it. The dates will be out as well, and all the rules, everything that you need will be out. That will be circulated by the MCS soon. And honestly, I will share my experience. Moot court has been one of the best aspect of law school. Obviously, besides the curriculum that we have, academic curriculum that we have, and you all, I really encourage you all to participate. There's someone who's asking, is it the same proposition for upcoming moot? No, we will have different propositions for both the moods. Prolucio was just an introductory mood for you all. So Prolucio was the first event of MCS 2020. The second events will be your ranking rounds, and further you will once you qualify with your in these rounds, you will be allowed to represent the college at international as well as national moot courts. I hope any query regarding the upcoming moots we'll be sorting out. We'll have a help desk, right? Like I said, we'll have this help desk available to you very soon. All the questions and queries will be answered by them. No, the previous ranking will not be considered. So what happens is every year, every academic year, we have new rankings. So anyone having their old rankings will not, they no longer are eligible, as in those rankings are not applicable anymore. You will have to participate again and then get your rankings. With respect to the upcoming moot, will students be given access to Manufactura and SEC for research? Well, this we will be conveying regarding this after a short while. I will not be able to comment on this. Will definitely answer on this after a point. Anyone wants to moot can start. This is the best part. What is Prolucio? Well, Prolucio was the mock that you saw right now, presented by Rushika and Anita. So they showed you how the simulation that was. So they showed you how a moot court works and how it is. So that was your Prolucio event. We have the RK, we have the IRRs. Then we'll be sending you all to the moot courts outside. We'll also, okay, one more thing. The MCS also wants to convey that these are not the only things. Throughout the year, we intend to have workshops or other events in order to hone your skills. So do not worry if you do not make it through the rounds. And do not worry about it. We will simultaneously be working on your skills. All right. So with that, we come to the end of this session, and you guys have a break for the next few minutes. I hope everyone's filled the Google form. That is the most important part to get your attendance, and we shall see you in the next session, that is the final session. Thank you.